That pattern to mention my advice. Judgment, sorry, man. In view of the discussions above, the conviction of the appellant under Section 302 IPC is altered to one under Section 304 Part 1 IPC. Accordingly, the appellant is sentenced to undergo rigorous imprisonment for 10 years for the offense under Section 304 Part 1 IPC, and the conviction and sentence imposed by the London Trial Court under Section 324 IPC are upheld, as the evidence clearly establishes the appellant's culpability for voluntarily causing hurt to PW3 with a dangerous weapon. Both sentences shall run concurrently. In the event the appellant has already undergone the substantive sentence as above imposed by us, and his detention is not required in any other case, he shall be set at liberty forthwith. Before parting with the case, we would like to put on record our appreciation to Mrs. S.K.Sahoo, learned advocate representing the appellant, for rendering her valuable help and the assistance towards arriving at the decision above mentioned. This court also appreciates the valuable help and assistance provided by Mr. Sarath Pradhan, learned additional standing. Admittedly, the petitioner did not succeed in securing relief. However, her case underscores a critical issue as to had she not requested her answer script, she would have not known about the non-evaluation of one question. The petitioner's the petitioner's case, while unsuccessful, has highlighted a critical flaw in the system, and her grievance regarding the non-evaluation of a question was legitimate and genuine one. Through her efforts, she succeeded in bringing to the court's attention a procedural lapse that demands rectification. In any other circumstances, as the one in front of us, this lapse would have gone unnoticed, potentially altering the candidate's chances of proceeding to the next round, or they could have successfully gone ahead for the next round in the selection process. Nevertheless, we presume that this could be the solitary case. Be that as it may, if such cases arise, it may raise the alarming possibility that similar errors may be affecting other candidates who remain unaware of the lapse. Such errors are unacceptable, particularly in examination like the Orissa Judicial Service, where accuracy and integrity in marking are paramount. Needless to mention how competitive examinations are the cornerstone of countless aspirations. For a large number of young individuals, these exams represent years of relentless preparation, often involving rigorous schedule, significant financial investment by families, and personal sacrifices. The stakes for these aspirants are extraordinarily high, as these exams often determine the trajectory of their future. It is therefore imperative for OP number 2, the OPSC, to exercise the highest level of scrutiny and adopt rigorous quality control measures during the evaluation process to ensure that the entire process is carried out with the utmost care, fairness, and diligence. Examiners and authorities must remain vigilant, as even a minor oversight can irreparably damage a candidate's hopes, undermine their hard work, and shake the trust placed in the examination system. OP number 2 OPSC is expected to take this responsibility with the seriousness it demands, as fairness and accuracy are non-negotiable in competitive examinations that hold the dreams of millions. In an effort to address the petitioner's concerns regarding the alleged non-evaluation of her answer to question number 5A, this court took the exceptional step of arranging for her answer script to be independently assessed by experts from three reputed universities to ensure a fair and unbiased evaluation of her performance. Unfortunately, despite this thorough reassessment, petitioner did not achieve the necessary marks to pass the examination. As a result, while the petitioner's grievance regarding non-evaluation was partly addressed through the court's intervention, and it was found that the evaluation process had a procedural lapse, the results do not alter her eligibility for the next stage of the examination. However, considering the mental trauma and financial burden the petitioner has endured in pursuing this case to highlight the said lapse, this court deems it appropriate to award compensation of rupees 1 lakh to the petitioner, which shall be paid by the Odisha Public Service Commission within a period of 60 days from the date of this judgment. Accordingly, the writ petition is dismissed on merit as the petitioner has failed to substantiate her claim for further relief. It is made clear that the compensation is awarded to acknowledge the procedural flaw brought to light and to serve as a reminder for OPSC to maintain stricter scrutiny in its evaluation process.
I agree.